to be nice. And that's what happened. They brought a direct appeal in Burton versus Sills, and the United States Supreme Court affirmed, meaning there is no right to keep and bear arms at all in the state of New Jersey, because the federal law doesn't apply, the federal Bill of Rights, and there's no state constitution, and the United States Supreme Court affirmed that in the early 70s. And I was a practitioner, and still am, in New Jersey, and people would come and say, hey, can't we challenge this under a second? I go, no, I've been held in contempt for bringing a frivolous motion by U.S. Supreme. The Second Amendment doesn't apply in this state. And it wasn't until Heller, and then one follow-up case, very important, McDonald, that even New Jersey would have the Second Amendment applied to it. Can you imagine? So Heller was jurisdiction out of what? Not out of a state. Heller was jurisdiction out of Washington, D.C., which meant there was no need to worry about incorporation arguments, which was pretty brilliant. Because any court could just say, well, it hasn't been incorporated, just like Burton versus Sills. We'll ignore it. It hasn't been incorporated to the states. It hasn't been incorporated to the 14th. Show me the case that did it. They avoided that. Because Washington, D.C. was federal, there's no incorporation necessary, and Heller made the decision finding that D.C.'s gun law was unconstitutional, finding there's an individual right, not just to keep and bear arms, but also an individual right to self-defense. A lot of people overlooked that in Heller. And then you had the McDonald case a couple years later, and then McDonald, that challenged Chicago's gun ban. And McDonald was the case that incorporated the decision of Heller against the states. And that meant, finally, that the Second Amendment of the federal Constitution could be applied to any state or city, even though it was a federal Bill of Rights amendment. It applies now throughout. Yes, thank you. And it really is something to cheer about. It truly is. Because the McDonald decision was as important, if not more arguably in some places, than Heller. And when you read the decisions, there's a lot of it that's very well written, but there's other areas of the decisions that are leading to various litigations. And one of the things out there right now is, you know, we have a right. What does keep and bear arms mean? What does that even mean, keep and bear? Well, keep, we mean possess. But bear, we argue, is to carry, right? So basically, keep and bear is to have and to carry. Well, the question becomes, to what extent is the carry portion, the bear portion, enforceable? And when you have states like New Jersey who essentially prohibit the ability to carry a firearm for self-defense, where does the Second Amendment come into that? So you're seeing various cases come about with different results in different jurisdictions, and eventually the Supreme Court is going to have to rule, because there's different diverse opinions all through as to carry of a firearm. Plainly, you have the individual right to keep and bear arms in your home, but outside your home, where does that right, how far does it extend? Now, I've been in arguments over this in courts, and I've tried to explain to the judge that the American Revolution wasn't fought from the colonists' bedrooms, right? Okay? I mean, I think they were bearing arms. Some were out there carrying them, even at Lexington and Concord, which supposedly was a pistol shot. Someone carried that pistol over there, right? Well, these are the battles that we're going to be fighting, and it's going to keep on fighting. And interestingly, you might think, wow, New Jersey didn't have a right to keep and bear arms. Isn't that interesting that a state wouldn't have its own state constitutional right to keep and bear arms? Well, neither did New Hampshire. New Hampshire didn't have a right to keep and bear arms in its state constitution until 1982. 1982. Now somebody might say, well, how could that be? And of course, part of it is, it was so unthinkable because it was so accepted and understood. Of course you have this right. What do you need a guarantee for that? I mean, it's some of the arguments that even at the time of the Constitution, when it was being debated, folks were afraid. I think Henry from Virginia, he opposed having a Bill of Rights. Didn't want it. You know why? Because he was afraid that if you made a list, they'd say those are the only ones that you had. And he said, no, we got all these rights, and we don't need that list to limit us, which is why you see the 9th Amendment, which basically says in so many words, just because it ain't written here doesn't mean you don't have it. And that's where the right to privacy was actually found by the courts, by using that, okay? But there are folks that were afraid of it. But New Hampshire didn't have that, even though New Hampshire had other very interesting rights that other states didn't have, including the right to revolution, right? You all know that. We have a right in our state constitution to revolution. Let me read that one to you real quick. Government being instituted for the common benefit, protection, and security of the whole community, and not for the private interest or emolument of any one man, family, or class of men. Therefore, whenever the ends of government are perverted and public liberty manifestly endangered, and all other means of redress are ineffectual, the people may, and of right ought to, reform the old or establish a new government. The doctrine of resistance against arbitrary power and oppression is absurd, slavish, and destructive of the good and happiness of mankind. Okay, I assure you, if you post that on Facebook, you will be investigated by the Obama administration. Okay? But that is our right to revolution. We had that, but not the right to bear arms. And in 1982, when the right to bear arms was put in, it's really a great right, as stated, and it's even clearer than the feds. And here's what it says. Tell me how beautifully simple and direct it is. All persons have the right to keep and bear arms in defense of themselves, their families, their property, and the state. That's New Hampshire's 1982 right to keep and bear arms. And yet, even with that stated as plainly as it is, even in New Hampshire, the case law has not done what you think it would do when it comes to respect of our state constitutional right and of the federal establishment by way of SCOTUS, Supreme Court of U.S., and even the incorporation of it to the states. The battle is ongoing, and we have issues in New Hampshire that are, of course, quite different than in New Jersey. In New Jersey, for example, possession of a slingshot is a felony. 18 months in state's prison for mere possession of a slingshot. So luckily, we are very blessed and fortunate to live in New Hampshire, where we don't have the laws that crazy and extreme. And they really are, because if any of you who carry, avoid New Jersey, because New Jersey respects no other license at all from any other state. And the Jersey license is a virtual impossibility for anyone to get. And if you have your handgun, even unloaded, in New Jersey, and you don't have a carry license, and you're not within the narrow exemptions, the penalty is up to 10 years in state's prison. And here's the kicker, people can't even believe I'm telling the truth. I swear this is true. 10 years in state's prison with a minimum mandatory 3.5 to 5 years with no chance of parole. In other words, if you have your unloaded and cased .22 pistol and you have it in your car, right, and you are not within a narrow exemption under Jersey, such as going to the target range going between your place of business and home. These are just the narrow, or using it while hunting. So in other words, you decide to take it to your friend's house, unload it and in a case, to show him your new handgun. I've had this case, okay? Or you have it by accident because you come from a free state and you happen to not understand, like Pennsylvania, where you have a carry license and you venture into New Jersey by accident. If you're convicted of this, the judge has no discretion whatsoever. You will get 3.5 years, no chance of parole over whatever number the sentence is, whether it's 7 years or 10 years. And the judge has no discretion. And if any of you followed a number of the cases I had in the news down there, like Shanine Allen and Brian Aiken, and on and on. I mean, and it's a continuous number of these folks. Those are some of the more famous ones. But you know, we are fighting to protect these individuals that are 100% law-abiding individuals, no prior criminal record whatsoever. They have licenses from the other state, so they're licensed, and they are looking at becoming a felon and doing 3.5 minimum mandatory time for mere simple possession of their lawfully acquired handgun. I mean, it's staggering. Like I said, be thankful that you're here. Now, that doesn't mean that there aren't problems here. There are problems here. Problems that we have here can go directly to our carry license system and things that need to be fixed and changed. And, you know, there's work going to that. We currently tried to get what we call constitutional carry through, where you're not required to have the piece of paper. You know, almost like what the Constitution says, right? Keep and bear arms. Why do you need that piece of paper? Maine just passed it, and it was signed into law, and it will take effect in October. Vermont's had it for forever. Vermont's had it. So the two states on either side of us, no carry license required. But for some reason, we can't be trusted in the same manner. I don't understand that. So there's work that needs to be done here. And the problem is that there can be and is abuse in the gun laws. Now, I researched this, really researched it, historical research, because Dave, like me, we love history, we love it. And there's so much that's not known until someone points it out about what occurred in the past. And you know, I did the research, and I looked up the original New Hampshire gun laws. And I don't know if you realize this, but under New Hampshire's gun laws from 1923, that's when our law took effect. In 1923, our carry license law that we're now under was enacted, and there was even a possession law at the time, barring possession and acquisition, etc. And they only had 2 categories of persons in 1923 in New Hampshire that were prohibited from owning a firearm, from buying a firearm, from possessing a firearm, and carrying a firearm. And those 2 classes, because I had the original law, felons and foreign-born unnaturalized citizens, or persons, unnaturalized persons. So if you were foreign-born and an unnaturalized person, you had no right to bear arms. So who were they talking about with that? I'll tell you who they were talking about. They were talking about French Canadians, because it was a major push against French Canadians. They were talking about Polish. They were talking about Italian, and they were talking about Irish. And where were these people? Primarily the immigrants that were legal immigrants now. They're not illegal immigrants. These are legal immigrants that have come to work in the mills, to work the jobs primarily down in Manchester, right? And there was a movement for unionization and such, and simultaneously with this immigration issue, you had, and it was in New Hampshire, and I've traced it as well, the rise of the Ku Klux Klan. And you need to know, folks, that It was the Ku Klux Klan and their political movement, and you can pull the article if you want to see it yourself from the Historical Society, the rise of the Ku Klux Klan in New Hampshire from 1923 to 1927, just for New Hampshire. And prior to that, it was huge in Maine. Thousands in Maine. Thousands. And the movement was growing. If you go to the library and look at the covers of the Union leader from the 20s, and I did all through this period, every day on the cover there was another news story about the Klan. The Klan was huge. It was a political force that had to be reckoned with. And New Hampshire's 1923 gun law traces directly to the Klan's agenda in New Hampshire, because they broke up, balkanized their national approach. And I documented this as well. Their approach for New England focused on the immigrants and ethnicities that they felt could get them leverage here. And that was different than what it was down south and what it was out west, etc. They focused their prejudices. And so French Canadians was on their list, Polish, Italian, etc. This was their agenda for New Hampshire. And they had rallies of thousands, and the politicians were listening. And they were really afraid of these folks, these foreign-born, unnaturalized persons, being able to defend themselves. So they took away that right to bear arms from them, and they defined suitable person. You're not a suitable person if you're one of those two categories. And you know that today, that language, suitable person, is still in our law. With its absolute racist and disgusting heritage, it is still there as a relic that is employed to still bar law-abiding citizens from the right to keep and bear arms. Individuals that have no prohibitors. In other words, they're denied their right to carry because a chief claims that they're not a suitable person, even though they are legal to possess firearms under both federal and state law. Please tell me how I can be legal under both federal and state law to own a firearm, but I'm denied my right to bear it because of, quote, suitable person. Well, there's cases pending now where we're fighting these challenges and we're raising what my research has uncovered, and we're able to show that the same abuse, just put into a little different format today, but it's the same abuse, and why that suitable person standard was put there in the first place is still being applied, and it needs to go. So New Hampshire has, unfortunately, an ugly history when it comes to its 1923 gun laws, and we need to get rid of that. We need to finally say enough's enough. I mean, you know, folks today will throw a fit over a historic emblem of the Civil War, right? The Confederate flag, for example. They'll have, flying over Fort Sumter is somehow a problem. I mean, in a historical, we're not going to appreciate that history yet. When you have something that is in law, that's founded in racism, now that gets to stay. Where's the outrage? It needs to come. And that's where the outrage needs to go. Not over historical symbols, but of something that is really in the law affecting good people. And that's happening today in New Hampshire. Now some of you may wonder, or maybe don't know, I'd like to take a moment to tell you how the gun laws work in New Hampshire, because really it's almost kind of silly. And I'll explain it to you. You tell me what you think. In New Hampshire, if you want to carry a handgun, and you want to carry it loaded, okay? You are prohibited from carrying a loaded handgun concealed on your person or in a motor vehicle. Now, if you carry a loaded handgun in the open, if you carry a loaded handgun in any other way except concealed on your person or in a motor vehicle, you're okay. But if you want to carry it concealed on your person or in a motor vehicle, you have to have a license to carry that handgun. Okay, that's our license to carry, and you have to meet the suitable person standard, so hopefully you're not a foreign-born, unnaturalized person, and as long as you meet these standards, you'll get a carry license, and if you do not have it, then you would be violating the law because it applies to those two instances. However, if you want to carry a loaded, folding stock AK-47 under your coat, loaded, concealed, you don't need a license for that. And that's because it's not a handgun. Only handguns cannot be carried loaded and concealed. But rifles and shotguns can be carried concealed with no license.
Crop TV.